sorry I'm late. I don't know if anyone came from the city, but the traffic was horrendous. So, first up, I want you all to become expert witnesses. We are really short of really good expert witnesses. So what I'm trying to do is persuade you it's not that hard. Yes, it's as you say, you might get in the witness box, you might get in trouble. But if you're prepared, if your report's written well, if you're confident in what you're saying, you'll be absolutely outstanding, and we need really good expert witnesses. So please all think about doing it if you haven't done it yet. There we go. Okay, so what is an expert witness? An expert basically is someone who has knowledge of or experience in a particular field or discipline beyond what the ordinary layperson has. So you're experts because you've done your training as engineers, you've worked in the field, you've got practical experience. That makes you an expert, whereas the girl working downstairs in the bar is not an expert in engineering. She might be an expert in pouring beers, but she's not an expert in engineering. Here we go. The most important thing is the bullet point, last one here. You're paid for the time it takes you to form an opinion and to support that opinion during the course of litigation. You're not being paid for the opinion that you give or for the assistance that you give your client. So basically, you're quite entitled to say, I'm charging you, my client, $10,000 for this job, but I'm not taking that money on the basis I'm giving you the answer you want. I'm taking that money on the basis of giving you what my opinion is. And so long as you stick to that rule, you'll be able to do anything you like in court, because that's all the judge is looking for. If you get up in court and say, I've taken the money and I've given the client the answer he wants, that's it, hopeless, you're out of there. But if you can get up in court and say, this is my opinion, this is the reasons why it's my opinion and what it's based on, that's what you're entitled to get paid for. I'll speed through these a little bit because we don't want to spend too long on all this boring stuff. Why do we have special rules and procedures for experts in court? Basically, the rules of evidence say a person can come to court to give evidence about the facts, about what they personally know, what they've seen happen. If it's a car accident, for example, they can say they saw the car end up in the ditch. But nobody can give evidence about why it ended up in the ditch. That's a matter of opinion. However, the courts have allowed experts to come and give evidence about their opinions to say why the car ended up in the ditch. So long as the expert has qualities and qualifications and knowledge and experience and background in the science of why the car ended up in the ditch. So that's the exception to the rule. The basic rule is not allowed to come and give opinion evidence at all. But if you're an expert, then yes, you can come and give evidence about the thing that you're the expert in. There's a whole lot of legislation about all of this. And in Victoria, we've got these 5 different jurisdictions where you're likely to come to court. Federal Court, Supreme Court, County Court, Magistrates Court and VCAT. So if you're doing court work in Victoria, that'll be the 5 courts you come to. Each of them use the Uniform Evidence Act apart from VCAT. Each of them have their own court rules set out in their own acts and procedures, and each of them have practice notes which set out exactly what it is you have to do and not do when you prepare your reports. So if you're doing a case and you're instructed and it's a case in the federal court, make sure the solicitors give you the relevant practice note, and make sure you've read it, and make sure you've signed on the bottom line saying that you've read it and you understand it. If you've had cases in VCAT, same thing, make sure they've given you the VCAT practice note. We all get reports that say, I've read the VCAT practice note, but the case is actually in the Supreme Court. So I have to then and often nobody picks this up till the day before the trial, and I'm reading through your report and I'm thinking, oh bugger. So the first thing I then have to do is get you in the witness box, ask the judge if I can allow you to say that you've actually read the Supreme Court practice note, hope to God that you have, and hope to God the answer is yes, I have, and can we change VCAT to Supreme Court? So that's the first thing to make sure. The rest of that stuff, look, it's all relevant and it's important, but basically to say to the solicitors who are instructing you, make sure you've given me the right rules and the right practice note. All the different rules basically, they're all slightly different to each other. Basically, these are the things that they make you do. So they talk about what the general issues are, they talk about what your overarching obligations are, and I'll come to that because that's really important. They give procedural requirements, what the content's to be, what the procedural rules are, and something about shadow experts, which we won't have time to talk about tonight. So that's basically what they all talk about. This is the Supreme Court Code of Conduct, and this is also used in the County Court and in the Magistrates Court. So if you're doing a case in any of those jurisdictions, you'll be asked to say, I have read the Expert Witness Code of Conduct, Form 44A, and I have complied with it. So make sure that's what you've done. Basically what it says, I know it's a bit small font, but if you just Google 44A, you'll get this up anywhere anyway. You have an overriding duty to assist the court. impartially on matters relevant to the area of expertise, of your expertise. So that's the first thing. You have to assist the court. That's the primary thing you're there to do. It's not to act for your client, it's to assist the court. So if you say in your report, I think my client's right and I think they're wrong, that hasn't assisted the court at all. What you have, because you're not being impartial, what you have to say is, these are the facts, this is my opinion about those facts, full stop, end of story. It's up to the judge to then say, and that means your client's right or wrong. Second point, an expert witness is not an advocate for a party, so that's the same point. Don't say, I think my client's right. That's the judge's job to decide that. So then, number 3 is the things that you have to include in your report. Your name, your address, an acknowledgement you've read the code and you agree to be bound by it, what your qualifications are. The next one, D, the facts, matters and assumptions on which your report is based. So that's really important, because any opinion you give is based on what you're told by the solicitors or by your client. So you have to set that out in your report. And one of the main things you'll be cross-examined on, the best way we barristers can find to tear you down is to say the facts or the assumptions you've been given were wrong. So if you've been told by your client that their house is moving and they say, I've never watered the garden in 50 years and so it can't be me overwatering that's caused, differential movement of the soils or whatever. If I can put to you in the witness box, and the rest of your report might be absolutely right in terms of the science and the geology and geotechnical stuff, but if I can put to you in the witness box, here's video of your client watering her garden every day with 3,000 litres of water for the last 10 years, so the basis of your assumption is wrong, you'll have to agree with me, that's it, your report's out. So that's why it's really important for you to set out what your instructions are. Next thing is, if you've used any literature, so on and so on, that's all fairly straightforward. If there's anything that falls outside your field of expertise, and a lot of people don't do that, they just think, well, I wasn't supposed to do that, so I won't talk about it, but you do need to actually say that. Any examinations or tests or investigations you've done or that you've had someone else do. And then a declaration that you've made all the inquiries that you believe are desirable and appropriate. So you might be instructed, say, the client might say, I've only got $1,000, can you just give me a quick report without doing any destructive testing? What you'd need to say in your report in that case was, but I haven't done any destructive testing. So superficially this is what I think, but I can't be sure because I haven't done the destructive testing. And by the time the client comes to the barrister and we're getting ready for trial, the barrister will say to the client, go and find some more money, we need this report to be beefed up a bit so we can deal with this problem.
So does that still...
Sorry, Scott?
Does that still comply then, because the expert witness hasn't done everything? That's the point that gets me every time I do a report, because I've never done everything that I feel.
No. And so long as the stuff that's done is your opinion, so if the opinion is yours, you're okay. And if you're relying on testing done by someone else, you say that. So if you say someone's done a test on the number of levels of non-slip resistance coating put on a piece of paving or something, you can rely on that testing. So you've got someone in your office to go and do the testing of the levels of the paint. You can say, Joe Bloggs did the testing, his results are here attached to my report, they show that there's only 3 microns, if it was proper non-slip paint there should be 6 microns or whatever it is. That's enough, you're allowed to say that, and that will be acceptable.
But if there were a whole lot of tests that you would like to have done,
yes,
you're not really
no,
with that.
No, you're not.
That happens every time I go to court.
Yes, and you can't put your client in a hole and say, the client wouldn't pay me to do everything I'd like to do. But you will be cross-examined about it. If it's a decent barrister, they will say to you, but you didn't do this test, did you? You didn't do this test, did you? You didn't do this test. And you'll have to say, no, I didn't, I wasn't instructed to. No, I didn't, I wasn't instructed to. And that's where I'm saying if the other side's got a decent barrister, they will have said to them, fix up your report before we go to court. Spend the money on it.
Suzanne, if you don't mind another interruption, but just right on this point. I've recently been saying I've made all inquiries that are necessary and reasonable or whatever it is within my brief and scope. And then in the brief and scope, I'll say I've been asked to do a desktop study only, not to inspect the site because there isn't sufficient time. Is that an adequate way?
I think that's a good way of doing it. That's a really, and that also protects you from any claims that you've acted outside your ethical obligations as well, because you're not misleading anybody by saying that. and you're flagging as well for the solicitors and the client that there could be more work that could be done if they can pay for it. And if it's
Okay, but I haven't actually given the declaration that I'm supposed to give.
No, but
Modified.
yeah, it doesn't matter. It doesn't have to be word for word. It's just so long as you've declared what you've done. That's basically what they're looking for.
Right.
So, all right. So then the next one is, so that's the Supreme Court County Court Magistrates Court. VCAT has its own separate practice note, and it's quite a lot longer than the courts, because what VCAT does, it has a whole section in it on what the format of your report should be as well. So the Supreme Court lets you do what you like. VCAT has got to the stage now where they've seen so many bad reports that they've said, right, we're going to teach you how to suck eggs, basically. And I'll get to that slide in a minute. First up, this is the same provision in any jurisdiction. You have a paramount duty to the tribunal, not to the party retaining you. You have an overriding duty to assist the tribunal, and you're not an advocate, so that's the same wherever you are. And if you bear that in mind, whatever your evidence is, you'll be good. This is what must be included, and again, it's similar to the Order 44 one, which is your name, your address, your expertise, reference. Oh, this is a new one, reference to any private or business relationship between you and your client. What your instructions were, your facts, matters and assumptions on which your report proceeds, reference to other documents and reports and so on. And a declaration at the end saying you've made all the inquiries that you believe are desirable and appropriate, and as Patrick says, you can modify that insofar as I've been allowed to, or insofar as I've been paid to, or use appropriate wording. But then we get on to this bit, which is what format is recommended. So this is the bit where Peter was talking about the formats of his reports. If you're setting up a system yourself, have a look at this as a really good guide. You can get this practice note on the VCAT website, so just have a look at this. You need to have a cover page, which has the VCAT file number. And this is really basic stuff that so many people don't even do it. The date of the report, the name of the person it relates to, the name of the property, or the address of the property, the party that's been prepared for, and who was engaging you. You should use the same numbering sequences as other reports. So the worst thing is when you get a whole series of reports and everyone's used different numbering. We lawyers have no idea, and the tribunal member has no idea when they're making their decision. Are we talking about item number 4 or 5 or 6, depending on which report we use? So make sure your numbering system is corresponding. You should file it in hard copy. Now this is a government cost-saving initiative. In the old days, we could all file things in hard copy and with black and white photos attached because it was just to run through the black and white photocopier, no problems. Then the government said, right, we'll have everything filed electronically, but they can't cope with the big colour photo attachments. So now they've gone back to saying, right, we're going to have it in hard copy again, but you have to give me colour photos as well. So you, the expert, the solicitors will probably ask you to provide them with 2 or 3 or 4 copies of a colour report in hard copy that they can then take up to VCAT. Colour photos, you might think it's silly, but in fact it's really important. For someone who hasn't seen the site, black and white photos that you've photocopied 3 or 4 or 5 times, they're really, really hard to see what's going on. So I can understand why they want colour photos.
It's only acceptable if the solicitor's instructing you, obviously.
Yeah, exactly.
Because they get photos that have been faxed or something.
Yeah, exactly right. Exactly right. And in the old days, again, solicitors would have done all that. But these days, they're passing the buck to everybody else, and so they're saying to the client, oh, well, that's the expert's cost, that's not our cost. And, there's a big difference between solicitors and barristers, by the way, as you can tell.
Barristers.
That's right. Things like the report should be A4 size, stapled and not bound, be 2-hole punched. This is VCAT cost saving again, but it saves, they don't have registry staff to do all this anymore, so we do it for them. If there's a spreadsheet, it should be folded so that it can be read without being removed from the file or included as a separate attachment. So don't put things in plastic sleeves. Put them with the hole punches, and then if the plans, fold them and then fold them like that so that they fit within the folder. Have to file and serve them on the other parties. Has to be the same format as that you've done with the tribunal. Usually the solicitor will do the filing and serving, so you don't have to worry about that too much. And then sometimes they might want electronic format copies. And often if there's going to be a conclave of experts where the tribunal's ordered the experts to meet and be chaired by another tribunal member to have a meeting with the experts, they'll often ask for your report, or at least a Scotch schedule in electronic format, so they can work on that as a joint document around the table. I won't talk about that too much because we're not talking about what happens at the tribunal today, we're just talking about the report stage of it. So, all right, so that's VCAT, that's the rest of the practice. No, you don't need to worry about that because we want to get on with dinner. Basically, this is what your duties and your responsibilities are. So all of that, all wrapped up, is basically these points. Independent product of the expert, independent assistance to the court, objective unbiased opinion in relation to matters within your expertise, state your facts or assumptions on which your opinion is based, make it clear when something falls outside your expertise. If you think that your opinion is not properly researched because there's insufficient data, then you have to state that. And this is the other important one, 6, if you then change your mind, you have to tell everybody as soon as possible. And it does happen, you know, you might get a report from the other side and you think, oh, actually, maybe you've got a point there. And often it's not so much the cause of a problem, but the rectification methods, that often happens. So you might say, to rectify this, you're going to have to pull the whole thing down and rebuild, and someone might say, no, you could actually do it by doing this, this and that, and you can reflect on that and think, yeah, all right, maybe that is a reasonable option. So those sorts of things happen regularly. As lawyers, we always say to our clients, your expert will start out with a report and a position and opinion, but don't expect them to keep that opinion all the way through the proceeding. At some point, the expert will be given either further information, further facts, further alternative solutions, and they have a duty to the tribunal or the court to consider those, and if they think they're reasonable or feasible, then they have a duty to change their opinion or modify their opinion on that. So don't be scared to do that, and in fact, if you don't do that, that's really where you'll get into trouble as well. So, the other thing that I have to tell you about is the Civil Procedure Act. This is something that's only been around for a couple of years, and it's really coming to bite on all of us, lawyers and experts. The government brought in, it was actually the previous Labor government brought in the Civil Procedure Act to codify what we all thought were our ethical and professional obligations anyway. We all thought we had a duty to make cases run quickly, run cheaply, run efficiently, not take stupid points, not run arguments that didn't have a chance. The government has put this into the legislation, and the trouble with it is, if you don't follow the obligations in the legislation, the court can make penalties, including making orders for payments of costs and compensation against me and against you and against the solicitors. So traditionally, experts were immune from having to pay costs or being liable for the evidence they gave, but the Civil Procedure Act has changed that. And so that's where you have to be really careful that what you do doesn't contravene the Civil Procedure Act. I've got an example shortly of a case where that happened. The last thing you have to know about your ethics and your obligations, Institute of Engineers has a code of ethics. If you belong to the institution, you all will have signed up to that code. And basically it's pretty similar to the Civil Procedure Act. You have to be honest, trustworthy, act on the basis of a well-informed conscience, maintain your knowledge and skills, uphold the reputation and trustworthiness of the practice of engineering, and so on and so on. So that's another thing to bear in mind. If you were ever to be sued for professional negligence, that's something they would say, have you met that code or not? So the vibe of the thing's all pretty much similar, whichever bit of act or legislation or code you look at, but it's just pointing out there's a whole different variety of things. So when things go wrong, these are some examples of some cases where experts have messed up. Or not necessarily the experts have messed up, but someone has done something which has made the experts look bad. This case was the expert himself who messed up. He's a building consultant. This was a VCAT case. He prepared a report, and his report, as says here in the second paragraph, didn't comply with his paramount duty to the tribunal, didn't assist the tribunal. He was acting as an advocate for the party to the proceeding. He didn't put in the report what he should have. The format was all wrong, and it was not filed or served on time. So the filing and serving on time is probably the solicitor's fault, but everything else was his fault. This is a building consultant that's well known to most of us who do this sort of work, and this was one of the few cases where the tribunal actually took him to task for the way he carried on in his report. It was a case to do with some drumming and cracking tiles, and the owner of the tiles had a well-known ceramic tiling expert give his report. He 35 years of experience, did all the scientific testing, said this is why the glue hasn't adhered and all those sorts of things. This lunatic on the other side didn't even inspect the property first when he prepared his first report. He said, oh no, it can't be right. that expert doesn't have any qualifications. Yes, he's had 35 years experience, but he's not an engineer. This fellow himself's not an engineer either, by the way. He then went on to say that this expert is the problem with the society today, in that he's geeing up clients, telling them they've got great cases and they're going to win lots of money, when really they shouldn't be running these cases at all. And this is what he said in his report. So of course the tribunal threw it out. He has not had any regard to his report and evidence. And so the owner got an order for all the tiles to be pulled up and rebuilt, relaid, plus moving out of the house and everything else. So that's a really clear example of where your expert's gone too far. This one is, I think one of your members was actually involved in this. This is a case where a cleaning lady slipped in the bathroom at a school. There was a soap dispenser, and the soap dispenser had leaked soap onto the floor. And during the course of the hearing, she'd sued the school and various other people for the injury that she'd suffered. There were a number of expert reports prepared in relation to this soap dispenser and the coefficient of slipperiness of soap and tiles and all that sort of stuff. And what had happened was the expert who gave evidence prepared the first report. Unknown to him, the solicitors had gone to someone in his firm and said, can you make some changes to the report? This employee had made the changes, so then there was a second report. Had the same date as the first report. It wasn't filed or served. No, nobody knew about it. No, hang on, it was filed and served, but the expert didn't know about it. Then there was a third report. So the barrister got hold of the first and the second reports before the day before the trial and said to this employee in the firm, oh, could you make these other changes as well? Which he did without the expert knowing. So then there was a third report. So the expert, poor expert, gets into the witness box, he's giving evidence, someone asks him a question based on the second report, and it becomes apparent he'd never seen this second report, and yet his name's on it and he's giving evidence about it. It then became apparent there was a third report that nobody had seen because the barrister had organised it and hadn't told anybody about it. And Justice Dixon in the Supreme Court was really angry about all of that. And using the Civil Procedure Act, he said, all of them have messed up, the barrister, the solicitor and the expert. So the expert was liable because it was his firm and his employees who'd done this and he'd not been properly aware of what was going on. The barrister because he'd got the report and got changed and hadn't told anybody, and the solicitors because they'd done the second report without telling the expert and so on. And what it meant was the expert had to indemnify the plaintiff. So the plaintiff was the one who did the other side. She got a cost order against all of them. And the expert had to indemnify the plaintiff, solicitors and barristers for 13.33% respectively for their liability to pay plaintiff's costs. And then the plaintiff's expert, solicitors and barristers each had to pay 1/9 of the defendant's costs. So everybody had to pay part of the cost for the other side because of this mess up with all the reports. So I don't really know how you can stop that happening other than have really tight controls over what goes on in your own office and what documents the solicitors and the barristers are sending around to everybody, and checking really carefully that when you get in the witness box, the document you're relying on is the document that everybody else has. That's about the only thing I can tell you, I think, about that. The next one is juror constructions, which was a case where an expert was engaged to give evidence about programming of works. It was a claim for all sorts of things, but basically the extension of time claims. And they used a building consultant who's very well known, been around for 35 years, done everything, and he gave, as part of his evidence about all the defects and all the incomplete works, he also gave evidence about the time and the programming of the works and whether extensions of time claims were valid or not. Other side objected and said this expert is not a programming expert. And so they went through the whole history of this expert and what he'd done and hadn't done. And it transpired when he was a student, part of his course involved a programming module. When he ran his own building business, he used programming software, but it was just a small domestic business, and this was a bigger commercial property. And all of that had happened 20 or 30 years ago anyway. Since then, he'd done training on programming, but hadn't actually used it himself. And he couldn't really say anything more than he was aware of it in terms of what he does with his other matters, being an expert witness. And again, it was Justice Dixon. He said that this was not enough to qualify him as an expert to give opinion about programming. Now, for all of us who practice in this area, we were really upset with this decision because it's impossible to get experts as it is. We can't get an expert to deal with every single little bit of a claim. So if we've got a claim for building matter, for defects, incomplete works, extensions of time, variations, all sorts of things, we can't get an expert to deal with each of those. It's just not cost effective, it's not practical, and yet Dixon's sort of heading down that road saying this is what you're going to need to do if you're going to run a case in the Supreme Court about this sort of stuff. So I guess really what that points out for all of you though is to say, if you're asked to do something about an area that you've got a little bit of knowledge of but not a great deal, say to the solicitors and say in your report, this is my expertise in this area. I think it's enough to give me enough qualifications to have an opinion, but you all need to tell me if that's right or wrong. And if you think it's not enough, then go and get someone else. And then, lastly, this is the last one. This was a slip and fall case in a Coles supermarket. Plaintiff had leaned into the freezer cabinet to get out some dip. She'd fallen over and hurt her shoulder. When she stood up, she saw 2 pieces of cardboard on the floor. She hadn't seen them when she fell, but she saw them when she stood up, and so she thought she must have slipped on the cardboard. At trial, she got an expert who said that the 2 pieces of cardboard left on the floor decreased the floor's slip resistance when stepped on. And as a result of that, the court awarded her $120,000. Coles appealed, went to the Court of Appeal, and before the Court of Appeal they said that expert hadn't done enough investigation to be able to make that finding. And they said what the expert engineer should have done is test the degree of slip resistance on the sole of the thong she was wearing, and bearing in mind how much she weighs, what the supermarket floor was like, all those sorts of things that they should have done. And because the engineer hadn't done that, the Court of Appeal said, yep, you're right, and overturned the decision. So she ended up with nothing. So again, it comes back to do all the required investigations. That's all I think I need to tell you. So, any questions?
Just before we have questions, those of you I introduced